This is a hearing of an appeal from the Republic of Trinidad and Tobago. The court sits as a court of Trinidad and Tobago, where it is morning, while we here in the United Kingdom are in the early afternoon. I will therefore say good morning. The appeal is brought by Alfonsia Lares and relates to an action of partition and sale of a domestic property in San Fernando, which is jointly owned by her and members of the same family. The appeal concerns the appellant's defence to an action for partition and sale on the basis that she has acquired ownership by adverse possession. The appellant is represented today by Mr. Charia, assisted by Mr. Walesby. The respondents are represented by Mr. Beharilal QC, Mrs. Ike Ashraf, and Mr. Abdul Ashraf. I will introduce each of the justices who is sitting in this appeal and then invite Mr. Charia to make his submissions. I am Lord Hodge. Lord Kerr?
Well, I'm Brian Kerr. I'm very well known to Mr. Beharilal, but I want to echo Lord Hodge's welcome to Mr. Charia.
Lady Arden. Lord Kitchen.
Good morning.
Lord Leggett.
Good morning.
Mr. Charia, I would now invite you to make your submissions. Thank you.
Good morning, my lords and my lady. May I just check, when her ladyship was saying good morning, I did not hear, I lost audio. Is her ladyship hearing me?
Very well, thank you.
Brilliant. Thank you for your warm and cordial welcome, my lord. It is my pleasure to present this appeal. We respectfully believe that there are important issues which have arisen in this matter and which merit the consideration of the board. As this is my first hearing, I've made some notes. They are not copious, I assure you, because I do not intend to recite what we have stated in our written case at all, save that which I would need to repeat, not merely for emphasis, but to add to the points that I've already made. Now, with your kind leave, I propose to outline my approach today. And it is this: I should begin by offering some brief oral submissions to address your lordships and your ladyship on what we believe are the critical aspects of the appeal. We submit respectfully that the main issue on this appeal is a question of both law and fact. Now, the issue for us really is whether the appellant's alleged possession of the upstairs portion of the subject property since 1990 extinguished the legal right of the respondents to that upstairs portion. Now, as by means of an essential background, this claim was initiated, as my Lord Hodge would have pointed out, by way of an application for partition. And that was done because there are 9 persons who hold the legal title. The appellant, who resides at the subject property, resisted that application on the basis that her occupation of the property extinguished the rights of the other persons in respect of their legal title. Now, she hinged that assertion on the fact of her possession. Originally at the High Court, she would have done so on 2 bases, essentially for the entire property and an alternative claim for the upstairs of the property. Now, we would have adopted an approach at the Court of Appeal based on the evidence in the matter that the appellant would not pursue her claim for the entire property. And so respectfully, what we are maintaining is in respect of the appellant's relief at paragraph 3, which your lordships and your ladyship will find at page 47 of the record. Now, because this relief at paragraph 3 of the defense and counterclaim is critical, with your leave, I propose to recite it here because we will be making reference to this relief. Now, the relief reads in total, in the alternative, a declaration that the first defendant has been in continuous and undisturbed possession and exclusive occupation of the upstairs premises consisting of a living room, kitchen, front gallery, back gallery, 2 toilets, 5 bedrooms, a veranda, an internal staircase, and 2 sets of stairs located at the side of the house for more than 16 years prior to the commencement of these proceedings, since in or about the year 1990, and is entitled to exclusive possession of the upstairs premises. Now, it's a mouthful, I will admit that, but it's necessarily so, given the facts of the matter and the requirements of the law. Before I proceed any further, we have recognized certain, the uphill task in respect of asking or seeking the intervention of the appellate court. In recognition of that, we have had regard to 2 very important authorities from which we feel confident that we can convince the board to exercise its powers as we have sought in respect of reversing the findings made by both the High Court and the Court of Appeal. The 2 authorities to which I refer are the matters of Beacon Insurance Company Limited versus Mirage Bookstore Limited. Now, that is a judgment, its citation, the complete citation is 2014 UKPC 21. This, your lordships and your ladyship will find is at page 990 of the electronic bundle. In that authority, we have spent some time on paragraphs 12, 13, and 17, as we believe those paragraphs contain relevant learning in respect of the circumstances which an appellate court would hope to find before it exercises its authority in respect of overturning or reversing findings made by a High Court and a Court of Appeal. We have placed particular relevance and reliance on the statement of Lord Bridge of Harwich, as it emanated from the authority of Whitehouse and Jordan, which is paraphrased in paragraph 17 of the judgment in Beacon. Now, we've done this because it is our contention that the obvious basis for a number, if not all, of the judge's findings were on agreed primary documents. Now, we say that because regard would have been had by the learned judge in his judgment to several pieces of documentary evidence. And we say that as that inferential finding was made by the learned judge on these documents, then we readily contend that the appellate court would be in as good a position now to reconsider and accept our arguments based on an interpretation of those documents. Now, we say that because throughout the judgment of the Court of First Instance, we have noted several impermissible findings of fact, and we say that they do not arise on the whole of the evidence. Now, I will attempt to set out clearly identifiable mistakes in the judge's evaluation of the evidence as a starting point, which we believe will be sufficiently material to undermine the conclusions that were drawn. Now, we also would have had regard to the statements by Lord Neuberger in the matter of Re B, a child, and that those are care proceedings. The citation is 2013 One Weekly Law Reports. In that case, at paragraph 53, the learned Justice of Appeal would have set out 3 criteria which we think is important in the context of understanding our criticisms of the findings of the judge. And this criteria, we say, gives rise to the basis on which an appellate court would exercise its jurisdiction. Those criteria are where there's no evidence to support the conclusion drawn, where the conclusion drawn was based on a misunderstanding of the evidence, and where the conclusion drawn was one which no reasonable judge could reach. We are respectfully contending there are several impermissible findings of fact that were made by the judge, and there was either no evidence to support those findings, or the finding was based on a misunderstanding of the evidence. These identifiable mistakes in our humble submission are sufficient to undermine those conclusions. Now, I want to jump, with your Lordship's permission, right into the meat of it and introduce our first criticism, and that is this. The judgment which your Lordships and your Ladyship will find is at page 194 of the electronic bundle. I'm drawing the board's attention to paragraph 36 of the judgment, where one of the criticisms, one of the conclusions that the trial judge would have found is that the appellant did not precisely define the upstairs, and also that she did not demonstrate by evidence that that part of the building was capable of being possessed by her to the exclusion of all others except licensees. Whilst your Lordships are looking at that paragraph, I invite your Lordships as well to look at paragraph 26 of the judgment, where he says that whilst the appellant occupied the upstairs, it was not exclusively occupied by her, in the sense that others did have access to the upstairs. Now, others did have access to the upstairs, and the appellant's attempt to deny access to the upstairs would have only happened after the death of the appellant's brother James, which was in 2004. Now, we submit that the judge was wholly wrong to make those findings. And we say that because the appellant's plea in respect of her possession for the upstairs of the subject property is very instructive, and if your Lordships would bear with me, it is at paragraph 3.8 of the defense and counterclaim. This will find, your Lordships and Lordships will find this at page 49 of the electronic bundle. Now, we have regard to this paragraph because we submit that that contention, that plea in the appellant's pleadings is undisputed. As I would have mentioned before, the plea is instructive, and I propose to recite it. It's not very lengthy. It's set out as the first defendant has been in continuous, exclusive, and undisturbed possession of the upstairs to the exclusion of the other claimants and defendants since in or about the year 1990. The appellant's evidence in support of that pleading can be found in paragraph 12 of her witness statement, and that your Lordships and your Ladyship will find is at page 448 of the electronic bundle. At the High Court, the appellant submitted that this plea was undisputed. At the Court of Appeal, the appellant submitted that this plea was undisputed. And in our written case, we have submitted that this plea is undisputed. And before we go to the fact of it being undisputed, there is, in our respectful view, need to consider the authority of our Court of Appeal in the matter of MI5 investigations and MI5 investigations limited and Centurion. Now, that case, your Lordships will find at page 1090 of the electronic bundle. That case is important because of its relevance in respect of undisputed pleas. Now, in that judgment at paragraph 6, Justice of Appeal Mendonça explains the operation of a critical aspect of our civil proceedings rules. And that part of the civil proceedings rules is part 10, 5, 3, and 4. Now, these parts deal with the defense. What the learned judge is saying at that paragraph is that by setting out a bare denial of a defense, that is not sufficient. And by doing that, what the party is doing is allowing a court or permitting a court to make a finding that without a proper denial, and a proper denial is set out later on, the description of a proper denial, it would have entitled a court to make a finding based on the allegation to which there's no proper denial. So we submit that the respondent's answer to the contention of the appellant in respect of her exclusive possession of the upstairs was not properly made out. We say that because...
Does that mean that the judge was required to make a finding in your client's favor?
Yes, absolutely. That is one of our principal contentions.
I carefully noted that you said that a court would be entitled to make such a finding. Is it your submission that the court has no option, even if the evidence given is contrary to the state of the pleadings? He must find in favor of an appellant or a plaintiff or claimant who has made an averment which has not been denied.
Well, I would like to answer my lordship's question, but I want to understand it in the context of this case. And I understand that if there were contradicting evidence, a difficulty would arise. But in this scenario, what happened was there is an uncontradicted plea. And as I would have pointed your lordships and your ladyship to paragraph 12 of the witness statement, I did so because that aspect of the appellant's witness statement was never the subject of cross-examination in the case.
Was the appellant not subject to cross-examination as to the access that her siblings had to the upstairs in order to have access to the wares, as they were described, in the upstairs portion of the property?
Yes, the appellant was subject to cross-examination on that issue. And I propose to address your lordships on that, and your ladyship.
Before you get to that, I mean, if it is the position that her siblings were entitled, or at least did have access to the upstairs property in order to obtain the wares, is that not an indication that she was not in exclusive possession of the upstairs of the property?
No, our contention is no, that there being some form of access would not militate against the possession of the appellant. And we do so on two respectful bases. The first is the entire manner in which the question of access to the wares was brought about was, as we say, it was a straight set of circumstances, because this question of access to the upstairs does not arise on the pleadings at all. So the respondents in their pleaded case never said that they had access to the upstairs. Secondly, the respondent, yes, my lord.
Yes, you're making a point about the pleadings, but if we turn to page 126, which is the defense to the counterclaim, the opening statement in paragraph 1 is so much of paragraphs 2, 3, and 5 of the defense repeated in the counterclaim as avers that the first named defendant was in continuous, exclusive, and undisturbed possession of the property for a period in excess of 16 years is denied. And then if you turn to page 128, we see at paragraph 2c, after the death of the parties' parents, the parties continued to live on the property without the express permission of each other or anyone, but under an understanding that the property belonged to everyone, so that each party residing at the property did so pursuant to this understanding, which gave rise to the tacit permission of each other. So we do have a pleaded case that there was no exclusive possession of any part of the property.
Well, my lord, I'm happy that his lordship would have put that issue to me in that way, because we have a complete answer for that. And I need to go back a bit just to set the scene for the answer. The plea of the appellant was to exclusive possession. That plea we say is undisputed. The evidence of the appellant at paragraph 12 was not contradicted. Now, we say that is undisputed, my lords, because very simply, the requirements of part 10, 5, 3, and 4 set that where a defendant intends to dispute an allegation, he has certain requirements in law. According to the rules, he must state his reasons for doing so, and if he intends to prove a different version of the events from that which is given by the claimant, he must state his own version. Now, I'm quoting from that part of our civil proceedings rules. My understanding is that a copy of that was forwarded to the registrar a short while ago. And I say that because I want to go back to his lordship's first point.
Could I ask you another question when you're giving me your complete answer, and that is this: was any objection taken to the cross-examination of the appellant? Was it said to the trial judge at any point these questions were improper or inappropriate?
That is something I will check, and I've made a note to answer his lordship on that, but I would want to get back to the overall plea. Now, just if his lordship should bear with me. Now, that paragraph that his lordship was referring me to in the defense and counterclaim is what we call a blanket, in my respectful view, what we have termed a blanket denial. We say it's blanket because it really takes up so much of the claim without actually answering the appellant's contention in respect of the upstairs. Now, that is important because the language of the plea used by the defendants in that defense and counterclaim, and those are the respondents in the appeal, the language does not speak to the upstairs portion, and that is what the rules require. The specific contention of the appellant was the possession of the upstairs. However, there's no specific answer. And
with respect, Mr. Shari, at first instance, the claim by the appellant was exclusive possession of the whole property with a fallback of possession of the upstairs. It was only in the Court of Appeal that you abandoned, or the appellant abandoned, the claim of possession of the whole property.
Yes, my lord.
Yes. And the pleadings have to be read in the light of that.
Yes, of course, my lord. But in respect of that, we say that it may be termed a fallback, but it is actually an alternative claim. And in our respectful view, it has always been maintained. Evidence by the appellant was afforded in respect of both aspects of the claim. It was therefore incumbent on consideration of the claim that due regard was given, not just for the pleaded case of the appellant in respect of the whole or the part, but due regard should have been had in respect of the evidence that the appellant afforded to the court in respect of both the whole and the part. And so in respect of the suggestion that that plea at paragraph 1 of the defense to counterclaim be ineffective or an effective answer to the appellant's contention, we say no, respectfully, because it does not take into consideration the specificity that would be required. It does not, although it offers a denial, it does not give, as the rule requires, it does not give the reason for the denial, nor does it give a different version. If I could go a little further on that, it would be, and your lordships and your lordship will see no language like that appears in the pleading. It would be, in respect of that paragraph 3.8, the respondents deny that the appellant was in exclusive possession because the respondents would have had access and so on and so forth. That does not occur. Now, in respect of the issue of tacit permission, we want to suggest respectfully that the question of tacit permission, as contained in our written case, is really something which the board has rejected in the matter of Smith and Molyneux. Well, that case is at, let me just get my referencing, is the electronic bundle before your lordships. And this is at, let me just find the page number, is at page 1223.
Thank you.
In that judgment, the board would have expressly rejected the question of whether permission of that sort could be implied.
Could you give me the page number again, please, Mr. Chair?
Yes. Just bear with me, my lord. That your lordships will find in my index, it starts at page 1223.
That's the last page of the bundle, and it seems to be a textbook.
Oh, my apologies. I will then supply the reference as soon as I can. Because
passage from Mr. Jordan's book on adverse possession.
No, that is not my lord. I assure his lordship that is not the case. I will give referencing and pass it on to your lordships momentarily.
What's the name of the case?
1190, I believe. 1190.
1190. Thank you very much. It's the full name of the case is Smith and others against Molyneux, and the citation is 2016 UKPC 35.
It's Lord Kerr and Lady Arden sat on this case, yes.
Yes, indeed. And in recognition of that, we felt fairly we felt a certain degree of confidence going forward that the board in this case would find reasoning with our arguments. Now that we've covered the issue of the undisputed pleading, I want to now go directly to our submission on that. We were saying in answer to Lord, yes, my lord.
I thought you were going to address the Smith case in your submissions, because on my reading of that case, it's saying that you can't have implied consent as a matter of law, but there's nothing to stop you having it on the facts and understanding that you can occupy the property with the consent of the other owners, which would prevent the possession being adverse.
Well, my lord, on the facts of it, there's absolutely no evidence to support that there was permission. And we say that because in all of the evidence that would have been put before the court by the respondents, there's a singular reference in the very last paragraph of the witness statement of Damiana Lares. Damiana Lares she is the second respondent. Now that statement, if I can take your lordships to that statement, is the only bit in our respectful view of evidence, in respect of the issue of permission. And I invite your lordships to look with me, your lordship and your ladyship, of course, to look with me as to what that paragraph says. That your lordships and your ladyship will find this at page 434 of the electronic bundle. Here's what that paragraph says. It says, no one objected to the first defendant staying upstairs with her children. She was a member of the family and a part owner of the property. In fact, no one had to ask to live there. When there was space, someone lived there. So in that paragraph, what you have is no mention being made about the upstairs. What you have is no statement being offered about the appellant being given permission. You do not have anything upon which, any material upon which tacit or expressed permission could be inferred.
Well, I wonder about that, Mr. Charlie. This is not someone squatting on someone else's property. This was a lady who was entitled as a 1/9 owner, or someone who had the potential to become a 1/9 registered owner of the property, to reside in part of the property. Surely that evidence in paragraph 8 of Damiana Lares' witness statement is wholly consistent with the family allowing members of their family to live in what had been their parents' house.
Respectfully, my lord, we would disagree. And we would disagree because if it is that the contention of the respondents was there was some form of tacit permission, they were required to lead evidence on that. And I hear your lordships on considering that paragraph as evidence, but I ask your lordships to consider that paragraph in conjunction with the letter written by this particular witness. Now that letter, we've made several observations about that letter, and perhaps now is a good time for us to go to that letter because
Do remember that you are facing concurrent findings of fact, and it is not normally the practice of this court to hear appeals on findings of fact in the face of concurrent findings by the local court.
Yes, my lord. We have had due regard to that, but it is our permission that those findings of fact, as I would have set out in my earlier remarks, cannot be supported by the evidence which was led in the matter. We've looked at the document in totality, and that letter is important because, not just because this witness wrote that letter, but because of the exact terms in which the letter expresses certain views. And if I can take your lordships to where the letter is located in the bundle.
Thank you.
It is at page 123. However, I will ask your lordships to have regard to an email which was sent by our Mr. Sully, where he annexes a clearer copy of the letter. That document, which is at page 123 of the bundle, isn't very clear, and we apologize for that. But the clearer copy would have been sent to the registrar by email. Now, we've had regard to this particular letter on the question of permission, because it is undisputed that that witness, Damiana Lares, would have sent this letter to the appellant or the appellant's daughter in any event. Now, the language in the letter is very informative, because we submit at the outset that what this letter is a communication from one of the title owners to another person in respect of the behavior of the appellant. Now, the observations that we will make about the letter are that it starts off as a very a clear example of a complaint by a person who has been excluded from the subject property. There's nothing in the letter which speaks to any permission being given. As a matter of fact, yes, sorry, Mr. Garrett.
I'm so sorry to interrupt, Mr. Charrier. Just to indicate, I don't have the letter that Mr. Charrier is referring to as a fresh copy sent to the registry.
I do apologize for that. I would have thought that my learned friends would have had, they made several references to the letter in their written case. Can I just ensure, I know Mr. Sully is following on, can I just ensure and take a note that to ensure that Mr. Biarra gets a clean copy as soon as possible? I know Mr. Wheelsby is also following on. I do apologize for that. Right, so my submissions about the letter.
Is one of your juniors able to send Mr. Baharilal a copy immediately?
But if I can ask for your lordship to give me 2 minutes, so I can step away from the computer and ensure that that indeed takes place.
Mr. Baharilal.
My lord, I don't want to interrupt Mr. Charrier's speaking time, so if that can be emailed in due course, I'll deal with it.
Thank you very much. We'll work on that basis. We'll give you your speaking time, Mr. Charrier.
Thank you very much, my lord. So in getting back to the letter, my point about the language is that it's indicative of a complaint of this person who was excluded from possession of the property. It also says certain very important things. Firstly, I have looked at paragraph 2 of the letter. Now, paragraph 3 of the letter. What the writer is saying is that the house is in a disgraceful and dilapidated state. Now, I want to submit on an interpretation that ought to have been drawn by the learned judge in respect of the language contained in the letter. I say that because we are of the respectful view that due regard was not had to the full contents of this letter. As a matter of fact, we are of the respectful view that the letter received a very little regard from the learned judge. And this letter, in our view, is contemporaneous documentary evidence of a disputed fact, at least as it pertains to the exclusivity of the occupation of the appellant. Now, going back now to that word dilapidated, what you would find, and what we hope your lordships agree with us on, is that the complaint speaks about the appellant's occupation of the property and the condition in which the property was, at least at the time when the letter was written. That is important because in our respectful view, a complaint would not be made like this had the appellant not been in occupation of the property, at least exclusively, for some time.
How can you say for some time?
Because
we simply don't know.
Yeah, yes, my lord. Respectfully, this letter is dated, on my reading of it, 5-09-00. So
the letter in September 2000, at a time when the appellant's brother was still alive and living in the property.
Yes, my lord, but he was living in downstairs of the property. So
in any event, Mr. Trujillo, it speaks to your client being in occupation of the property, and that was the fact. But it doesn't say anything at all as to the exclusivity of that occupation, nor to the question of her having the requisite intention to exclude all others. I mean, it acknowledges that she was in occupation, but that is nothing to the point. It's wholly unexceptionable.
My lord, we respectfully disagree, because at paragraph 10 of the letter, there's language in there that we will ask your lordships to look at. Now, at that paragraph, what the writer is saying, and I want to paraphrase what is said. It says, your mother liked to cuss and play, that she owns the upstairs and can do as she pleases. That we have interpreted as an objective view on the way in which the appellant was treating the upstairs, because what you have is one co-owner, Damiana, complaining in writing about the fact of the behavior of the appellant in respect of the upstairs. But it doesn't stop there. Earlier in the same paragraph, the writer says, and I need to read it for your lordships because of how it is set out. It says, maybe you do not know, but if the dead had power, you all would have been dead in that house a long time ago. Now, that phrase to me speaks again to the question of how long the subjects were in the property. And we have
no one is disputing her occupation of the property, as Lord Kerr says.
Yes, yes, my lord. And we have recognized that the question of the intention is something of a challenge. However, and before I go to the factual evidence of intention, I want to just address your lordships very briefly on the question of what sort of quality of intention is required. And in doing so, I would ask your lordships to consider with me the authority of Pye and Graham. In that authority, which is at page 1038 of the electronic bundle.
Thank you.
We have placed particular reliance on the statements made by Lord Hutton at paragraph 76 of the judgment. Now, what his lordship was saying in that paragraph is he was establishing essentially what is the quality of the intention. And I wish to read.
I'm so sorry, but I think you gave us a wrong reference. Again, there's no page 1038.
It's page 1066 is paragraph 76.
Well, I do apologize.
Sorry, maybe my fault.
Okay. Very good.
1038 is the first page. 1066 is the paragraph, I think, to which you wish to take us.
I'm very grateful, my lord. I think this is another one of those, yes, page numbering issues. In any event, this paragraph, there's a line at it's the second line of the paragraph where his lordship says, where the evidence establishes that the person claiming title under the Limitation Act has occupied the land and made full use of it in a way in which the owner would, I consider that in a normal case, he will not have to adduce additional evidence. And later on, his lordship says, but it is different if the actions of the occupier make it clear he is using it in a way in which a full owner would, and in such a way that the owner is excluded. Now, it is obvious to us that Damiana was of the view that, at least Damiana was of the view that the appellant was in occupation. But as the question of intention goes, that paragraph 12 of the witness statement of the appellant, on which the witness was not challenged, sets out very clearly her mental state in respect of the property where of the upstairs, where she says, and I wish to go to that paragraph because it is important. She says, this your lordships will find at page 448 of the electronic bundle. She says, I have been in continuous, exclusive, and undisturbed possession of the upstairs premises to the exclusion of the other claimants and defendants since in about the year 1990. So what we are submitting is that there is a very telling example of the intention of the appellant, which has not been challenged. But in any event, there's no question as to the manner in which the appellant was occupying the upstairs. The upstairs of the property, clearly defined, is a domestic setting where it is accepted that this appellant was occupying. And we are submitting that based on the learning of Pi. Yes, my lord, sorry.
But that does not reflect the terms of the letter. What it says is your mother liked to cuss and play that she owns the upstairs and can do and say as she pleases. Clear implication from that is that is not accepted by the author of the letter.
Well, I apologize if I put it across as acceptance. What I meant to say was that it shows at least the writer was of the view that the appellant was behaving in a particular way. So in our respectful view, that's essentially, yeah, I'm sorry, my lord?
She was, the author of the letter was clearly opposed to that.
Yeah, I see.
Lord Liggett wants to answer your question.
I just want to, it's not just a matter, though, is it, of what the appellant says her intention was. The judge had to consider all the facts, like, for example, the fact that there was an internal staircase, and as he found, she made no attempt to stop people coming up the stairs to go and use the crockery when they wanted to. So that is inconsistent, for example, with intending to exclude the others from that part of the property.
Well, my lord, in respect of that, we want to start our submission on that, on the question of what sort of control would have been required to be exercised by the appellant in relation to the upstairs, because we believe the issues may be becoming a little muddled. And it's muddled because, respectfully, because of a misinterpretation of that evidence. Now, respectfully, the legal position is that what the claimant has to establish, and by the legal position, we are referencing here the authority of Rosalind Ramro, which is at page, but that is, the citation is 2010 UKPC 14. In my index, it's written as, starts at page 1188, but I may be wrong about that, as I was wrong with the earlier reference. So I apologize. I have, however, given the citation. Now, that case is important because it would have set out what the appellant was required to plead. So the appellant was required to plead a particular definition of the upstairs, which we submit happened in this case. Now, what happened in the interesting, as the judge termed it, in exchange of evidence, is that the witness was cross-examined about a cabinet. Now, respectfully, there are a number of things that was wrong. And I take his lordship's point earlier about whether there was any objection to that cross-examination. I will come back to that, but at the start, we will say what is obviously wrong is that there was no pleading in respect of access to the upstairs. So that does not arise on the pleading. There was no evidence offered by the respondents in respect of access to the upstairs. And those two things in combination create a wholly unacceptable and unfair state of play, because this appellant would not have been prepared to come to court and deal with a question of whether there was access. Now, and I say that because we don't accept that there was access, and we think it was fairly, it is very, it is notional. And I use that word specifically because Mr. Jordan, Queen's Counsel, in his treatise on adverse possession, deals squarely with the issue of notional entry. At paragraph 7-52 of that work, which was sent to the registrar for your lordship and your ladyship's assistance, what the learned author says very clearly is the question of notional re-entry does not disturb the control of the claimant person. Those questions that were put to the witness deal squarely with the question of control. But if your lordships look at the quality of the answers that came and the way the question is structured, what you would find is that, and I propose to go directly into and refer to those parts of the cross-examination because it is critically relevant. We are submitting that those 4 lines, the exact words are, and your lordships will find this at page 233 of the bundle. Mother had a tea set, dinner set, glasses that were used on special occasions, housed upstairs, cabinet upstairs. Members of the household could go up and take wares. Now, this is an entirely notional conclusion because the fact that members could go does not mean members actually did. And to deal with the question of negativing the appellant's control, evidence should have been led to show that there was actual access. And that ties in with a point I wish to make on the question of whether the access needed to be locked off or not. The setting for the instant claim is a family setting. And the test that is established by Lord Justice Walker and Rosalind Ramroop is, and if I can read that particular test out, because I think it is relevant, it says here.
What paragraph of Ramroop are you reading from?
Yes, I am going to paragraph 24 and 25.
That's page 1163.
I am very grateful, my lord. 116. So, what his lordship is saying here is that if a claimant is to establish title by possession, adverse possession to a part, the pleadings must define, and we've dealt with that, and lead credible evidence that it was capable of being possessed. And we submit that that was indeed so, based on the definition, at least, of the upstairs. But also that the claimant did in fact enjoy possession throughout the limitation period. But there's an exception to the definition which is materially relevant. His lordship says, the credible evidence that that part of the building was capable of being possessed by the claimant to the exclusion of others apart from the claimant's licensees. Now, there's no suggestion in that word that the exclusion has to be absolute, because there's the exception there is that other persons could have access as long as they fall into the category of licensees. Now, that issue was not addressed or dealt with in the cross-examination. That issue, and respectfully, that really arises because the question, this issue of access to the upstairs via this means never found its way for the court's consideration on either the pleaded case or in the evidence of the respondents. So I respectfully think that that issue was overlooked. But certainly, it must be notional because there's no evidence of the access even occurring. The word, the language coming out of the answer, which is the troublesome bit of the evidence, it is members of the household could go up and take wares. There's no evidence that they actually did. Even if they did, there's no evidence of the frequency. And even if there was frequent, there's no evidence that this was without the permission of the appellant. We think that that is fairly dangerous. Now, so that we don't lose track, so that I don't lose track of where I am, I wish to go back now a bit. I hope I have answered his lordship's question in respect of the our view on.
She would have to prove that she had given consent for the removal of the wares from the cabinet.
Yes, Your Lordship. If it were that was an issue on the pleadings, we would have had to prove it. But that was never an issue. As I said, that was never pleaded by the respondents. Now, if the respondents had said in any of their pleadings, well, we had access to the upstairs, then it would have been required that the appellant to prove that that access was pursuant to a license. But
Mr. Carrier, you don't have to plead every piece of evidence that you are going to lead in support of a proposition. You have the clear proposition that I read out to you in the defence to the counterclaim, to the effect that this was a family property and that members of the family could stay there in effect with the permission of the other co-owners. But that was the entire case that you were facing and having to meet, because the onus was on you to establish the adverse possession.
My lord, respectfully, I would say that a fact so material to the matter should have been more succinctly set out on the case of the respondents. And I would say that because it deals with the specific issue of the upstairs, which we again suggest respectfully that there's no question on the pleadings that there was any sort of dispute with the appellant's claim to be in exclusive possession.
We have that submission. I don't think we'll benefit from it being repeated. You progress your case.
Yes.
Thank you.
Yes, please, my lord. I thank the court. Now, there's an interesting piece of there's an interesting issue which arises on the judge's assumption of the payment of certain utility bills, and I wish to go to that now.
Thank you.
Now, the trial judge would have drawn inferences on the documentary evidence, which we submitted were not open to the court to be drawn. Now, we say that because as a background to that, we would like the court to look with us at a statement made by Ms. Bernadine Abraham, which is at page 220 of the bundle. Now, that statement arises in her cross-examination, so your lordships will find that in the notes of evidence. She says, I was paying the bills at 21 to 23 Padmore Street. Everything, water rate, electricity, land and building taxes too. So we have interpreted that statement to mean that this particular witness is contending that look, she was the one who was paying for all of these things. That's her evidence. Now, at paragraph 14 of the judgment, the learned judge, which your lordships will find at page 198 of the bundle, the learned judge finds that the respondents did pay rates, and as a result, that he equated that payment of rates to occupation. Now, we say that is fundamentally wrong, and we say that because even though Bernadine says in her cross-examination that she was the one paying for these rates, she never mentions that in her evidence in chief. So it is a statement on which there was no pleading and there was no evidence in chief. It is a statement that arises in cross-examination.
Why does that matter? I can see that there might be objections to evidence arising for the first time on re-examination on matters which didn't arise on cross. But why is evidence on cross-examination any less of any less weight than evidence in chief?
Well, it is the duty of the witness, in our respectful view, and on the way the rules are constructed, that the evidence that you wish to adduce to a court to consider is contained in your witness statement, so that in fairness to the process, in fairness to the parties involved, the other side understands the case that they are coming to court to meet and to prepare for. But it also matters in the instant factual matrix, because that statement directly contradicts other evidence in the case. Damiana Lares says something which we think is very important. At paragraph 7 of her witness statement, which your lordships will find at page 432 of the electronic bundle, she says that she was the one who was paying land and building taxes. She evidences this claim by annexing a check and receipts. Now that is important, because what you have here is a witness saying, look, I paid this, and here's my proof. That's quite apart from Bernardine saying, I paid everything, and there's no proof.
Well, is it not accepted that for a considerable period of time, your client didn't pay things and that other members of the family did?
Yes, please, my lord, it is.
That's accepted. Well, it really doesn't matter whether Damiana or Bernardine were the ones who paid. The fact is, this is an undisputed fact that members of the family paid the household bills, and your client occupied the upper floor.
Yes, but my lord, our position on that is this. His lordship, in the first instance matter, placed a significant amount of reliance on the payment of the bills equating to occupation. And obviously that is wrong. It is obviously wrong because Damiana was not in occupation, yet she proved that she was the one who was actually paying these bills, at least in relation to the lands and building taxes. Now that contradicts Bernardine, but it also raises questions as to the credibility of the evidence which Bernardine provided to the court. And even if we were to take on, yes, my lord.
It's highly irrelevant, isn't it, to the question of the appellant's intention? Because if it had been her intention to exclude the others from the upstairs of the property, at least, you would expect to see her taking responsibility for payment of the outgoings for the upstairs of the property. And the fact that she doesn't indicates that she's treating it as a shared possession.
My lord, in our respectful view, that is not the case, because, respectfully, the maintenance of an expenditure is certainly not the test in relation to occupation of a part of the premises. In any event, there's nothing on the pleadings to suggest that the appellant could produce a separate receipt for a utility for the upstairs. There's nothing to suggest that the upstairs was separately metered or anything of
That's her problem.
That's the point.
That's the problem for her.
Yes. Yes.
The difficulty is you're claiming that she was having exclusive possession with intention to possess exclusively the upstairs, but she didn't have a separate water meter. She didn't have a separate electricity meter, and she allowed members of her family who were co-owners to pay the bills.
Yes, my lord. And we respectfully contend that requiring the appellant to evince her intention in that manner goes against the learning that I would have pointed the court to as set out by Lord Hutton in the matter of Pye and Graham, because the question of her intention is undisputed in respect of her witness statement. But secondly, there's no evidence she would have occupied the property as any occupier would. So the requirement for her to adduce additional material to show that she was in occupation of that part of the property, we believe that is a misplaced requirement. We actually respectfully contend that that doesn't arise on the law.
I think no one is disputing her occupation with her family of the upstairs. The issue is the nature of the possession, if you can call it that it was adverse possession, rather than, as the family pleaded and sought to prove, she was possessing the upstairs with the permission of her siblings.
Yes, my lord, I understand that. But as I mentioned, on the question of intention, as set out by Lord Justice Hutton, there was no requirement for additional evidence to be led, save and except for the appellant to show that she was using the property as any occupier would, that part of the property. Now, I'm going back now to deal with certain other aspects of the consideration of the documentary evidence, which we have the respectful view are impermissible findings. Now, there's a fact that His Lordship would have, as I said before, would have placed relevance on the payment of utility bills. But it is also a fact that there were no electricity bills introduced into evidence in this matter. Now, the scheme of that in the general thing, in the general matrix of this case, is that, and the importance of it is that Bernadine suggests that she was the one who was paying all of the bills. There's no electricity bill. We submit that that operates against Bernadine's credibility, but that is not the end of the matter. The assumption that His Lordship, that the trial judge placed on the payment of bills is undone, as it were, by an evidential issue. The documents which were supplied to the court in respect of the payment of these WASA rates are 2 agreement forms which were not signed by Bernadine. Now, Bernadine doesn't give any evidence in respect of that. On the face of it, the document was signed by the daughter of Bernadine. Now, this person did not give evidence in the matter, so she was not cross-examined on those documents. Now, that is important.
Why does it matter if you accept, as you have done, that your client occupied the upstairs and her siblings or family members paid the bills? Does it matter that we know who in the family paid which bill? I mean, the critical point is that members of the family were paying bills for the undivided property.
It matters, please, my lord, because it is a conclusion which the learned judge would have drawn based on his inferences from the document. And the learned judge concludes as a fact that those agreement forms are proof of payment. That is not a finding that would have been open to the learned judge to make, because the person who would have allegedly paid the bills did not give evidence, and in any event, that is an agreement. It's not a receipt for payment. I understand that Your Lordship is saying.
Again, I say, what does it matter if what the evidence was, if the conclusion that was reached, namely that members of the family paid the bills, not the appellant, is an undisputed fact?
Because, my lord, the payment of the bill does not equate to the members of the family having access to the upstairs or having disturbed the question of control to the upstairs.
Well, I have that point, but what is the point about going into individual documents if the overall conclusion is not in dispute, that the bills were paid? What inference is taken from the payment of the bills may be a different matter, but I don't know if this board will be assisted by reading through documents and who said what to whom, if you accept the overall conclusion that the family paid the bills.
Yes, it's important, my lord, because in the evidence given in the matter by Damiana, in her cross-examination, she says something which is very important. And if I could go to the notes of evidence, I'll take Your Lordships to why that is relevant. Okay. Let me get to that page. Now, it's important because in her evidence, at page, which would appear at page 217, Damiana says something very interesting. She says the house is a double house. Now, that to us jumps out because it clearly shows, at least according to Damiana, there's an acceptance of at least 2 separate living arrangements, or 2 arrangements, or 2 houses. Now that is important because the entire contention of the claimant is that the upstairs was capable of being possessed, quite apart from the downstairs. But also, if you have a party who is a title holder accepting that there's a double house, then clearly the fact that they would have paid bills in relation to the entire property cannot subsume, as it were, the question of the appellant's occupation of the upstairs. Then the equating of the payment of the bills does not amount to control, because the 2 properties, at least in the mind of one of the respondents, are separate. And whilst I am here on this page, I invite your lordships to see again at 7 lines down, where on that same bit of exchange and cross-examination, Damiana repeats a statement she made in her letter, where she says where she speaks about the behavior of the appellant. Her behavior was like she was acting in control of the upstairs of the property. That is important because it's the 2nd time she says that, but also it's the 2nd time when she uses the word control. That question of control, in our respectful view, speaks directly to at least how the respondent apprehended the intention of the appellant.
At what time period was she talking at this stage?
We would submit, based on the similarity of that statement to what is set out in the letter, at least when that letter was written. Now, that letter would have been written in 2000, but I ask your lordships to consider what we had referred to earlier in respect of the other parts of the letter, which admit to a state of events that predated the letter. The state of events is established by 2 things: the reference to the fact that the house was dilapidated, and certainly that means that the house would have been in the possession, or at least the control, of the appellant, because the appellant, my lord, is being blamed for the condition of the house. It cannot be that this person could blame somebody who is not in control. If I am in control of the property, then I certainly, or I have access, then I certainly can't blame the person who I'm saying is in control. The 2 things, they contradict each other in our respectful view. I hope that answers his lordship's question. Now, we wish to go on now, with your lordship's permission, to deal with other aspects of how the court would have misapplied, in our respectful view, the law and certain of the facts. One of the identifiable errors that we have found is in relation to the judge's view that the evidence that was required of the appellant was misconstructed, or at least in his mind, we would say. We say that because at paragraph 21 of his judgment, when he assesses the evidence, he says, and I want to read from the court in relation to that, and your lordships will find that reference at page 199 of the electronic bundle. What the judge is saying is the next issue concerns the upstairs. Now, the judge now turns his consideration, his mental consideration now is applying himself to the appellant's allegation to the upstairs. He says, the question is whether it was exclusive in the sense that others had no access and were excluded. Now, we have already submitted that the question of the others having no access is entirely the wrong test, because in our view, that does not consider access by licensees being accepted pursuant to the judgment of Ramro, and that is the observations of Lord Justice Walker. But also, what we wish to draw the court's attention to 2 authorities which we understand, which I understand was sent to the court by email, and that is that paragraph 752 of adverse possession by Stephen Jordan, Queen's Counsel, and also the case of Paradise Beach and Transport Company Limited against Price Robinson, which is the judgment of the appeal court. Its citation is 1968 AC 1072. Now, that authority is important because in that matter, the board was treating with a scenario, a similar fact scenario in our respectful view. In that case, what you have is that persons who were entitled to the property would have visited the claimed property. Not only did they visit, those were persons claiming under the will of the title holder in Paradise Beach, that is my words. What you have is that those persons visited the claimed property, and not only did they visit, but they also took away gifts that they obtained, produce and so on, because the claimed property in that case was an agricultural one. And what the board held in that matter is that their entry onto the property did not disturb or negative the question of the control by the person who was in occupation of the property. That is directly relevant to this case because, as your lordships would have had regard to earlier, the question of the notional access in relation to the wares is dealt with and taken up by the learning in that authority.
Do you have it in the bundle?
No, my lord, as I would have said, that authority was submitted by way of email. That and the next authority to which I am referring your lordships now. That is...
For future reference, one doesn't submit authorities by email late in the day. There are procedures to be gone through, and the board does expect those procedures to be respected.
My lord, I do apologize for the late submission of it. It arose after greater consideration was placed on the arguments. We did try our best to ensure that clear copies got to the court.
I won't detain you now because you've only got a limited time.
Yes. So the next authority, which also would have been supplied to the court by email, is that of the passage of the work of Mr. Jordan. That is relevant because of how the author expresses the concept of control. At that paragraph, what the learned author was dealing with specifically is the question of control. And he says, entry onto the disputed land, and I'm quoting from the work. This is at paragraph 7-52. He says, entry onto the disputed land by the true owner will not suffice to prevent a squatter who is in effective control of the land from being in possession unless the owner takes back actual possession. Now, we accept that this is not the purest form of squatter and true owner in terms of the factual matrix of this case. But we are contending that if it were that the access issue could trouble the question of the appellant's control, it would have had to been something that was greater than what was actually expressed. But it does not stop there. Even if we were to further examine the question of the notional access of the appellant, of the respondents, there's a piece of evidence which has escaped in our respectful view the judge's assessment. That piece of evidence, if your lordships would bear with me, is contained in the notes of evidence, and it directly relates to the question of the respondent's access. Now, we have contended that the respondents didn't plead a case with access and didn't prove a case with access. But in the notes of evidence, and in particular, I want to take your lordships now to the evidence of Ms. Bernadine Lares. She says something which was very important, and this your lordship and your ladyship will find is at page 222 of the electronic bundle. This is 1, 2, 3, 4, 5, 6, 7 lines down from the top of the page. She says, I don't know which rooms were occupied by which children. Now, this respondent who would have set out that not only was she in occupation of the downstairs, but she was paying certain bills and so on, she is admitting in that statement of not even knowing the layout of the rooms upstairs. That, in our respectful view, speaks directly to the question of knowledge and therefore access.
With respect, she doesn't say that she doesn't know the layout. She doesn't know which children occupied which rooms. That's what she says.
Yes, my lord. But if it were that there was some level of intimate knowledge or any sort of knowledge, that is a very basic question in our view that should have been known by persons having free and unhindered access. We suggest that that shows that there was no clear-cut access.
Okay.
Now, we have submitted these examples, as it were, of these findings of fact, but we wish now to move on to certain aspects of the consideration of the law.
Okay.
One of the issues raised by before the courts below is whether it was capable for the upstairs as defined to be possessed. Now, it's a very it's a basic consideration because it goes to the heart of the case. Our simple answer to that is yes. It not only does it is it capable, but it meets with the criteria, and the criteria, in our view, is both the criteria set out in law and also the criteria set out in our statutory provisions, and also the criteria that is set out in the common law. We say that because the Real Property Limitation Act in Trinidad contains a definition of land. Now, that statute, the statute I just referred the board to, is contained at tab 5 of the electronic bundle. That's the Real Property Limitation Act of Trinidad and Tobago, chapter 5603. The definition clause in that act, which occurs at section 2, subsection 1, contains a definition of land. Now, in our view, and on a reading of it, land in that definition includes messuages and all other immovable property and corporeal hereditaments whatsoever, and critically, and also any share, estate, or interest in them or any of them. Now, on the interpretation of that provision, what we have in this factual matrix is an appellant claiming an interest in a part of a building, and we say, because of the definition set out there, it is capable for her to claim that interest. That definition of land, as set out in the definition clause, applies to persons claiming possession of lands, because that is what that act deals with. Now, we want to tie that in respectfully, because we see a connection between that definition and the evidence given by Damiana, where she accepts or would have suggested that there are 2 houses on the property. Now, and we say that, but as a broader picture, I wish to address the board on a question which arose in respect of the impression of the claim that was before the court. This appellant did not seek a title in relation to the upstairs. We see that as being a fundamental misconception of the claimant of the appellant's case. It's fundamentally wrong, because in the relief that the appellant seeks, what she actually wants is a declaration that she's entitled to possession. She never sought title to the upstairs of the property. I'm pausing, my lord, because I see, all right, yes, I see Lord Justice Kerr is back with us. So, because she never sought a title to the property, a lot of the criticisms and misunderstandings in respect to that were raised in the Court of Appeal to a certain extent, we find are irrelevant, because one of the criticisms about the claim is whether practically, and this we see reference made by the respondents in their written arguments, what sort of practical implications would arise if someone is claiming possession of part of a property, a part of a house? How would you convey title? Would a bank accept that as a mortgageable property? Those considerations, in our respectful view, are irrelevant for 2 reasons. Firstly, we have not sought title, the appellant doesn't seek title. And secondly, in the context of the case, which is a claim brought for partition of property and sale in lieu of partition, if it is that the court wanted to consider the full argument of the appellant and even conclude in the appellant's favor, title would not need to be established. All that would need to be established is that this appellant, who is a 1/9 legal title holder, actually possessed a greater share than 1/9 in the property. And the practicality of that is that because the parties, the respondents would have asked for sale in lieu of partition and for the proceeds to be divided, if it were that a court found that the appellant would have been in possession, exclusive possession of the upstairs, her share would be greater than a 1/9 share. So it's simply.
Could you explain what you mean by that? What would happen to the ownership rights of the other 8/9?
Right. Now, the ownership rights arise out of the deed of asset. So what you have is that some of those persons, as they're entitled to law, have asked the court, because the property cannot be separated by metes and bounds in conjunction with what our partition ordinance provides, they've asked the court to determine the question of the title by selling the property and dividing the proceeds of sale. So at least some of the parties have accepted that I do not want now, I want to realize my title in this property by selling it. So the title and the way title is held is going to change. The way title is held is going to change. And that title is what leads to the interest of the parties. Now, respectfully, we contend that if each party has a legal interest, and that legal interest is created in the deed of asset, and they want to realize that interest, all they would need to do is apportion the proceeds of sale in accordance with that legal interest. And that's where our claim really hits home, because we are saying that the appellant's possession of the upstairs overreaches the legal interests of the other parties to the extent that the appellant would be entitled to a greater share in the proceeds of sale. Now, there is, in our respectful view, an additional consideration which arises, and it is that, just bear with me, my lord, I just need to follow my notes because I noted his lordship would have said, yes. I just want to go back a bit before I lose my train of thought in relation to the question his lordship put. How does that practically deal with the question of title?
I don't want to distract you at this stage, because you've got less than 5 minutes now before your period is up. So I would advise you to get through such points as you wish to cover. We can come back to that later if we need to.
Yes, my lord. Now, very quickly, in closing, one of the submissions that we wish to make is that we recognize that the respondents have adopted a position of the non-application, or as they have termed it, they are saying that the authority of RAMRUP no longer applies. And they've rested that on certain arguments which are contained in their written case. Now, we wish to respectfully draw the court's attention to the fact that the respondents at the High Court accepted, in our view, the application of RAMRUP, insofar as they took care in their written submissions to distinguish the application of RAMRUP, but they never at that stage disagreed with its application to the instant case. At the Court of Appeal, that stance adjusted slightly, where they would have suggested, well, the board in RAMRUP made the statement that the board made per incuriam, and it didn't form part of the ratio. Now, that, in our view, cannot be the case, because as clearly set out in the open paragraph of the matter of RAMRUP, Lord Justice Walker is dealing squarely with the consideration of a claim to possession. What the justices did in that matter, in our respectful view, is they considered part of the property as well, because that was a claim which was really advanced at the appeal stage. as the record will show. So now we see the respondents are saying, well, hold on, this authority doesn't apply at all. We are viewing that as a withdrawal from a concession that was made by the respondents at the beginning of the matter, that the authority is the position and common law. And we take the respectful view that that sort of withdrawal is, at this stage, really something that ought not to be permitted by the board. It is fairly late in the game, and it would be very, as my lady would have said, in the matter of Crane and Sky in-home service, that would permit a party to blow hot and cold on an issue that they would have consented to or dealt with at an earlier stage. It is our respectful view, though the matters are not on exact all fours as you were, it is very relevant given the considerations that the board would have applied in RAMRB at that stage. So, in our respectful view, we have, I mean, we would have set out our written case, but we feel confidently and are confident in the fact that we have set out several examples of the judge's mistaken assumptions of the evidence and conclusions which his lordship did not draw, which were open to him. Unless there's anything further that your lordships would wish me to, and your lordship would wish me to address you on, those are our oral remarks.
Your oral ones would be taken, submissions will be taken along with your written submissions. We will adjourn now so that the board can discuss matters, and we will resume this hearing in 10 minutes' time.
I'm very grateful, my lords. My lady.
Mr. Baharilal, the board does not need to hear from you on this occasion. We are very grateful to counsel and those who have assisted counsel for their submissions and the preparation of the papers which we had made available to us for this hearing. We will now take time to produce a written judgment which the board will promulgate in due course, and the board will now adjourn. Thank you very much.
Thank you, my lords, my lady.